Big breaking news. Stephanie Jones cannot re-amend her complaint. This is really good news for Justin Baldoni. Team Wayfarer, Stephanie Jones cannot change it. That means she cannot add Melissa Nathan and others to this against Justin. He's saying enough is enough. You took too long and you were sloppy. We went through all of this on the full show. You can always become a member by joining at our website. Go to popcornplanet.com. Click on over to the It Ends with Justice page as well, because that's where you can see diaries about the documentary that's upcoming, and you can become an investor as well. But without further ado, here is our conversation with Ron Zambrano about the other big Blake Lively news today. Big news coming in regarding the Blake Lively, Justin Baldoni lawsuits, and we got Ron Zambrano here to break it down. Welcome to Popcorn Planet. I am Andy Signore. I'm so excited to be back with Ron Zambrano. And Ron, we got some It Ends With Us news. Are you excited?
Super excited, but I love this opinions, 34 pages for lawyers who want well-drafted legal opinions. This is great.
Yeah, and meanwhile, I was having a lot of trouble understanding it. So let me see if I've done my due diligence in dumbing this down. Basically, for all you at home, there are many lawsuits happening, right? And one of them is the Stephanie Jones versus Jennifer Abel is one of the many lawsuits. The publicists are fighting. And Justin's team, Wayfarer, countersued and attempted to throw this out. And he basically had four main reasons for why the whole thing should be dismissed. Basically, you told our secrets. Jones took the private messages off the employee's phone and gave them to the New York Times, which helped sort of torpedo everything. You did a terrible job. You were in Europe during the crisis and generally made things worse as you were doing it. Number three, you stabbed us in the back. While still being paid by us, you were secretly feeding all this bad information to Lively. And then lastly, number four, you lied about us. You were telling the publicist that Wayfarer was running a revenge smear campaign, and then, reporting the sexual harassment, et cetera. Wayfarer says that was completely made up. So regarding those accusations, it was kind of a mixed bag, but the two most egregious stood. Accusations 1 and 2 are now dead. So basically, you told our secrets, you did a terrible job. The judge didn't think they proved that well, but the you stabbed us in the back and you lied about us, the defamation, the more meaty parts of it, those are still existing, and that's bad for Blake. And that, this is bad because this is now a publicist who is ruining her own client's reputation and relationships behind his back, and a judge basically Lyman acknowledging, this is a fair thing. We're going to keep this in, and now it doesn't get to go away. And this is, so to me, it seems like, yes, there's a little bit of a win for Blake's side, but this seems like the fact that Judge Lyman let those things stand is more of a win for Wayfarer. Did I do okay? Did that set it up? Let me know what I did wrong.
Yeah, no. So you're talking about the underlying facts perfectly. What is being alleged from the meat standpoint, the meat and potatoes. So these things were from the countersuit from Wayfarer were put into three separate legal theories. One was breach of contract. The second one was something more complex and nuanced, which I'll get into in a minute, which is you didn't engage in this contract in good faith, which is called a breach of the covenant of good faith and fair dealing, and then defamation. So the judge, in this I think a very wonderful opinion, really breaks it down. It's like, your breach of contract means you went to, you did a bad job. The you did a bad job facts break into two parts, and sorry, Wayfarer, you didn't plead it well enough. Those I'm kicking out. But with regards to the breach of the covenant of good faith and fair dealing, which is basically like, we're in a contract, and despite the terms of the contract, you should be acting with honor. You should be representing us with some type of honesty and a duty of loyalty into the contract, and you breach that. And the judge said, that's enough. That one can stay there. And the defamation one is the really salacious stuff, right? You're really talking crap about us. You're using internal information to basically torpedo us. So that's the defamation claim. And it is very well, but there's so much going, and this is so well written, and I could see why the judge is taking so long on the MSJ, on let's call it the lead case. right? But we can get into this, and we can really get into this if you like. But that's what's happening from a legal structural standpoint. And just for the viewers know, there's no evidence of anything. This is just what's in the complaint. The judge has to assume what's in the complaint is true. That's very different than the MSJ. There's evidence that the judge is looking at for the MSJ. But for this, it's just he's just reading the complaint, just the four corners of however many pages that complaint is, and making a ruling, assuming everything is true, and still didn't find enough for breach of contract, but enough for the other two.
Yeah, well, that's what I was going to ask next. As I'm scrolling through, guys, you'll be able to see some of it here because it's a lot to digest. But yeah, I mean, what I was going to ask you is, can we deduce anything from this on how Lyman's thinking? Right? How does this affect the Lively case? But as you just said smartly, it is not all the evidence has been presented in this one versus the Lively one. So some of the stuff that's getting thrown out, or because there's a whole part about, well, you didn't prove there was a smear campaign. Is in this document, which to me, as I read, we were all like, oh, damn, well, that's big news because that means Blake's not gonna be able to prove it either. But that doesn't mean that, correct? It means just in this case, based on the filings, it doesn't prove it, but that doesn't mean that the judge isn't thinking that it's not proven via the evidence.
Right. So what the judge is really criticizing is the attorneys. They're criticizing the attorneys, going, you're saying there's a smear campaign, but you didn't go and describe it or what it was, and that is a defect. And then therefore, I'm not allowing that claim based on those unfinished allegations to go forward. That's all it means. But I mean, you could read into it if you want, right? Because he may know something else, but technically, you're not supposed to read into that. No.
But let's read into it. As a lawyer, what are you reading into it? Do you think this shows any cards?
I think it does, because at this point, when these things were filed, everybody should have known enough from the evidence that's in the other case, right? Like there should have been enough, like we've been taking all these
Shared
depositions.
stuff, yeah.
Yeah, like it's the same parties, the same attorneys. If it was there if it was there in the underlying evidence in in the main case, it should have made its way to the allegations of the complaint, and it didn't. So it could be that it really isn't there.
Yeah, I mean, it's interesting. So overall, this doesn't necessarily mean anything specific for the Lively side of things yet.
No, and I'm from Lively's perspective, I would be a little bit concerned, because what this allows is that now they get to engage in discovery. So yes, so let's all zoom out for a minute. We all remember when the Wayfarer parties and their counterclaim was dismissed in the main Lively suit, right? We all remember that, and everyone's like, why didn't he amend? Oh my God, he dropped it. Well, guess what? Now he gets to move into these things through this claim, and the same people are involved. It's the same players, the same depositions that would have happened in the quote unquote main case can now happen now. Now you're moving forward, and they get to ask questions like, who did you talk to, and how were those done? They can ask for, I want a copy of the computers, I want a copy of the phones, digital copies of everything. The same things that they thought they were avoiding in the Baldoni cross complaint that no longer exists is now happening here.
Now, okay, any other takeaways that you saw or anything else that surprised you before I go to the next story, which is the fact that there's these delays and stuff? But this is, would you lean this more? This is a good win for Wayfarer more than Lively, yes?
Absolutely, yes, because now Wayfarer gets to engage in the discovery and the defamation, which is the more salacious thing.
So, okay, that's good. So that's the good news. The second part of today's update was the fact that Wayfarer requested a 1-week extension. Now, in this extension request, they're basically throwing it at Lively, saying that, for example, Lively's counsel identified nearly 1,000 trial exhibits for inclusion in the plaintiff's portion of pretrial order. It's difficult to imagine that even half the number would be put before the jury. Many are lengthy exhibits consisting of numerous text messages pages, which are obviously irrelevant, admissible under multiple rules without speculation. Due to the apparent technical issue, Lively's list of potential exhibits also does not make clear which page each exhibit ends, yada, yada, yada. Of the nearly 1,000 exhibits, at least 100 consist of articles and social media posts that were not produced in discovery and yet have yet to been provided to defense counsel in a format. So we've brought this to their attention, and they haven't really done anything about it. So they're talking about this overbreadth of information, how they don't have enough time, the 40 witnesses, et cetera, and then requesting, I guess, an additional week pretty much. Lively came back arguing this, saying no, da da da, we've done fine. That's not true. They're not being honest. They're both arguing. Regardless of who's telling the truth, the judge granted the extension and let Wayfarer have it. The court will then hold a video conference via Microsoft Teams next Monday, basically, I guess, or next week at 5 p.m. It's next Thursday. The parties will be provided instructions. The court will also have an all dial in, so public can call in. So we can't broadcast it, but we will be there to report for you what is said. But given that granting of that, I guess my question is, via all the complaints, Blake's denying it. Is this, I imagine it's a standard mudslinging happening, but from your perspective, who do you think's more in the right? Who's actually probably not doing the right thing here?
I'm going to give you a very lawyer answer, which is it depends. What I really think is happening is that the Baldoni attorneys are begging the judge, can you make a ruling on the MSJ so that we aren't killing tens or hundreds of hours of attorney time working on claims that won't end up at trial? Because this part of the attorney work, like preparing these documents for trial, this stuff is monopolizes everyone's time, and you invest a lot of brain and energy because you're thinking about not only the evidence but your narrative and how you're going to present it to the jury, and like you're constantly thinking about this stuff, and it takes a lot of attorney brain work, and it's why people settle, because this is really hard work. And these people are like set up for that. I could tell you from it, this is really hard work, but it puts so much more stress. You're like, we're about to expend hundreds of thousands of dollars in the next 2 weeks, and the judge may go, it was all for naught. And they're begging, like, can you make a ruling on the MSJ? Because if you don't include three, if you give us like half of a win, it's gonna cut down our time by half. So please, can you give us guidance instead of us reviewing thousands and thousands of documents? Because a lot of things they're complaining about in this letter are things that you bring up to the judge at the pretrial conference, which is, okay, here are the 1,000 exhibits. Of the 1,000 exhibits, here are all the things that are irrelevant. Can you please rule on it now? And the judge is going to be like, I need time for that. Here's this. They pointed out things that were in discovery. Can you make sure to exclude that now? It's called a motion to limine. At the pretrial conference, it goes, okay, yeah, I'll exclude that, or what's the relevance? So I read this letter as a kind of begging the judge, can you please save hundreds of thousands of dollars
Tell us where
between
you
both
stand.
sides? Because this may be stuff we don't have to expend anyway. And then the judges, whoever wins is going to go to the judge like, well, they owe us time for that, right? Now they owe us that time. So it really is that, in my opinion. This is really that.
No, I 100% agree. I guess that my next question then was just going to be like, why do you think Lyman's taken so long? Because obviously he knows this is costing a lot of energy, money, etc. And then does his granting of the extension, imply anything to you? Like, does this make it seem like a judgment is coming sooner, later? Doesn't this almost seem like, okay, fine, we'll have the extension, we'll talk about it. This to me almost reads like, we're not even gonna get it till after the second now.
Yes, so you probably won't get it till after the second. This is what Lyman's decision today signals. One, he read this and is not giving people more time by moving the trial. He's not moving the trial. He's not doing it, at least not today. There's a chance that he hears enough on April 2nd where he'll go, you guys cannot do a good enough job to prepare for trial that's currently set. I'll move it then, only to allow you to prepare. Like, no more discovery, nothing like that, and maybe a short continuance. But
how long do you think that typically is? If he were to push the trial on the second,
federal judges can do whatever they want.
But you think it's going to be another month, 6 months, a year?
Oh, it won't be that long. Probably a month max if he decides to do that. But the reason he hasn't moved it is to put so much pressure on the parties, to make it so unbearable for both sides. They're looking at the prospect of wasting money, that it typically forces people to call each other and go like, let's resolve this. Like, let's resolve this. And we've talked at length that there's just too much at stake that they won't do it. So the judge is like, listen, I'm going to put your feet to the fire. And if you guys it's not my fault you don't resolve the case and have to do all this work. It really isn't at the end of the day because they've known about these things forever. Like these dates have been set for a long time. But that's really what's happening. The attorneys are like, please make a decision so we don't waste time on work. The 80-page verdict form is crazy. Imagine you worked on 80-page verdict form. Every word matters. If anything is wrong, it's an appealable issue and you have to restart again. And imagine if like half of that doesn't matter. It's like there's so much. That's what the attorneys are doing. But the judge is like, I don't care. You guys, this is what you guys bought into. You guys don't want to resolve the case. This is the work. Sorry. And it's just it's a game of
It's
chicken that the
wild.
judge is going to win. It is wild. It is absolutely wild. And that's why judges are so, especially now, and they're like, I'm not moving the date. Like, I'm sorry, you're not ready. And if you're not ready, the judge can sanction you. Like, you know my rules. You should have been ready. I don't care that it's taken a long time. I don't care that they gave you 1,000 pages. Who's not ready? That side. Okay, I'm sanctioning you. It's like that. They put your feet to the fire, and it could end up wasting hundreds of thousands of dollars in attorney's fees. But that's the game.
So they were ultimately hoping he was going to answer the question and be like, "Oh yeah, it's coming. Don't worry." And instead, he delayed it even longer. Like,
Yeah.
well, you know what? Let's talk about it on the second, and then we'll
Yeah.
see maybe, which has to stress them out even more. I imagine it
Oh, yeah.
stresses both sides out. Like, no
Oh,
one's winning this delay. Like, everybody's paying
Nobody's
for this delay.
Someone had to find those 1,000 documents. Now someone has to figure out this technical issue, which is probably like a PDF Adobe issue, because that is annoying. Someone went and had to extract the social media right? Like someone's doing that, not putting in a digital format in order to put it
And
into
charging a lot of money per hour to
oh
do
my,
it.
all this is happening. So that's the lively side. And then once that's dumped to the other side, now they have to review it. They can't just like, ignore it. So now someone has to sit there and review everything. This is so
Right, they can't just throw it in
time-consuming.
ChatGPT like everyone else is probably doing nowadays.
No, there's no
So
way.
what is your betting man? I know this isn't a guess. What are the odds at this point now with everything you're seeing, this motion coming in to dismiss, but still keeping that Jones trial going, and now this delay? It sounds like you're betting that we'll probably know more about the trial come the second. If it's going to get delayed, that's probably a good time to do it because both parties will sort of say we're not ready, and the judge will either agree or not. And sort of on the second, we should at least know whether we're going to trial. When do you think, though, Lyman's going to release it? Because he must know at some point, I'm going to cut all this out. I should at least tell them. Like, at no point does that not get to him of like, even for my own work log and other cases I've got going, this is a waste of time. Like, when does he finally succumb? And like, instead of responding to Jones, why didn't he just respond to this by now?
Probably because Jones, delaying on Jones would have delayed the Jones matter. It also gives an insight to the parties. Listen, it may be a signal to the parties which we initially talked to of like, I'm taking this very seriously. I'm looking at everything very seriously. So understand how this is going to go. The way I read it, just because of what we talked about earlier, I really think he's going to slash some of the claims, some of Lively's claims. That's what I read. Once I read this last thing, I'm like, he's taking his job so seriously, and it's so well thought out and so detailed that he is going to have an opinion that cannot be impeached. Because remember, whoever loses is going to appeal. Doesn't matter who, right? Lively, Baldoni.
Right. He doesn't
whoever
want
loses-
anyone to be able to win that appeal. Yeah.
No, he's like, I'm writing this thing knowing you're going to appeal so that you have zero chance of the Court of Appeal disagreeing with me because I'm going to do such a good job. That's really what's happening. And that happened to me in my case against a celebrity last year. That judge took 90 days, and it was a 35-page opinion. And because he knew, he's like, I'm ruling against the celebrity, you're going to appeal, but I'm going to do such a good job to know that I don't have to repeat this process. And that's what Lyman, and again, that's all Lyman's doing. Lyman's not reviewing any of these documents. Like, they didn't present it to him. It's like, I'm not reviewing any of this stuff until I tell you I want to look at it. And that's what the deadlines are for. So maybe that's what he's saving himself also by kicking things out, because that way it doesn't get presented to him before he really, probably from his perspective, like, I don't want to look at this stuff either until I make a ruling on what I should be looking at or not.
It's just further. We all got plans this summer, Ron. When is this trial happening? I guess, but honestly, like, if they do throw some of this out, is that trial date of May still going to hold? And they'll
Yeah.
still do this. They'll do the lesser ones still on that time. So that even if some of it goes away, there's still probably a trial happening in May because it's probably not all getting thrown away.
Yeah.
But it could be a shorter trial. That's, I guess, one likely scenario. Or there's a scenario where he just says, look, on the second, guys, he could literally, they all agree, well, no, it's all still here. We have still so much to do. We're delaying a month to allow it, but only for the sake of preparing this. In which case that could give Lyman more time to still throw some of that out. Is that what I'm gathering?
I do not think Lyman will do what the attorneys want because the attorney's saying they won't be prepared. I don't think that's going to happen. It's like, I'm giving you a week. That's more than enough time. No more surprises. I don't think Lyman is going to move anything. He's not going to move anything for the attorneys. He'll move it for himself. He'll be like, listen, I need another week to finish this MSJ. Whoever listens into this April 2nd hearing, you want to hear anything implying when is he going to rule on the MSJ? The trial's not getting moved, in my opinion. Trial's not getting moved. What you really want to hear is what is Lyman going to reveal about when he's going to make that ruling? Because that is really the most important thing, because that drives what happens with these thousands of documents and all this other stuff, and also what happens at trial. I don't think he's moving the trial even on April 2nd. That's my opinion.
Interesting. So trial days still go there, even if he does dismiss some of it, likely still a trial is going to happen on that date, because obviously not everything is going to get thrown out. But that was interesting. If he is debating all of this, can he actually just tell them, yeah, my ruling's coming next week? Like, is he allowed to reveal that? Is that standard?
Sure, he could reveal.
I mean, do judges typically say, I know you got all waiting for this, like it's going to come in the next 2 weeks? Like, they will give timeframes?
Because he understands from this letter, even though they didn't say it, there's a whole paragraph dedicated. We don't want to do work that you are going to end up throwing out anyway in your MSJ ruling. It's not explicit,
which is
but
fair
it's
for them to point out. No?
Yeah. So to answer your question, I think a fair thing for the judge is to acknowledge that in open court, going like, listen, I'm acknowledging I don't want to waste people's time and money. So, and he could be like, I'm going to make a ruling by the end of next week, and I'm going to make dates in accordance to that expected ruling. He's not going to tip one way or the other, whether it's, all in, all out, or 50-50. I think that's what he'll probably do on the second in this conference. But I doubt he's going to move the trial. I very, very much doubt he's going to move the trial, but he can. Listen, I told you, before we got it, I have cases in federal court, one against Megan Thee Stallion. The judge in the same courthouse has had it for about 6 months. I don't, he'll let us, he's like, he'll call us when there's a ruling. And then once there's a ruling, then he'll set trial. That's some judges do that, right? Lyman didn't do that. Lyman's like, I'm setting trial dates and I'm not moving it, and I'll make my ruling when I want to. But he does not want to move that trial. He does not.
Man, we're all waiting in bated breath. What's going to happen? I'm sure both sides just are going nuts trying to figure out what do we spend our energy on. It is pretty wild to see how much is at stake and how much he's still holding it there. So, but again, given with this motion and everything else, it sounds like we won't really know anything until the second now. I imagine if he had this close, he would have just dropped it, right? If he had the summary judgment, or is there a version of this where he's going to drop it before the second, which is then we're going to address the responses of that on the second?
Yeah, there's again, reading between
anything's possible.
It could be conjecture where he knows already what's getting kicked out, and that way he can guide people what to do with what's left on the side. That's a possibility, that he already knows. He's just finalizing it. The other possibility is like, he's in the middle of it and he hasn't decided, but he knows he's given himself a deadline of sometime in April. That could be a possibility. We just don't know. What I do know based on what we saw in the Jones Works case, it's going to be detailed. It's going to be ironclad unless the law changes that would undo it. He's going to do an incredible job in that opinion, and it's going to be long.
Very long, and we will have Ron back to go through it and educate all of you guys. So make sure You hit that subscribe button if you haven't already. Hit the bell for all alerts as well. Smash the thumbs up and stay tuned. Sounds like this case ain't going nowhere, and it sounds like it may still happen in May. I guess I got to get my plane ticket run.
Yeah.
Stay tuned, everybody. It's still coming. Always appreciate you, sir. Guys, we got a lot more coming your way here on Popcorn Planet. Make sure to like whatever platform you're listening to, subscribe, all that jazz, share, and stay tuned. We got more coming for you every Tuesday, Thursday, and daily here on Popcorn Planet. And we're still here. What, Kim? We're here. We did it.
We are. We're here.
I like when we get to just play a clip and I get to like go to the bathroom and get a snack. It's kind of nice. And you guys like feel like the show's still moving. That was pretty fun. Insightful from Ron, don't you guys think?